Out of court business closure. How to close down your company yourself without filing for bankruptcy. If you're going out of business but don't have enough cash to pay the company's debts, you can follow a DIY approach. By following a workout plan outside the court system, you may be able to take things in your own hands, liquidate your business assets, and negotiate your own debt settlements. Check out this video for more information about the so-called out-of-court workout. Welcome back, folks, to another edition of Sweetie Kiwi. How you doing today? I hope you are doing fantastic. I'm doing marvelous, if you were to ask me. Yes, of course, we have a very sensitive and very serious conversation to have. The topic is very sensitive and very serious, but I'm doing fantastic, and I hope that you are doing as great as well. If you are doing as fantastic as I am, go grab a cup of coffee or tea or vodka and let's roll. I want to preface today's conversation by saying that this is not legal advice. We're not giving you legal advice here. We have done research and we are presenting to you the results of our research. And if you need specific advice based on everybody's situation is different, if you need specific advice, please reach out to an expert, a lawyer, a bankruptcy attorney, someone who has expertise in the field where you seek help. All right, let's first talk about the workout process. The idea is very simple. You or your lawyer calls each of your creditors and asks them to release you from the debt in exchange for some fraction of the full amount you owe. Why do you think creditors should do this? Very simple. It's often a better choice than suing you and trying to chase down your remaining assets while hoping you don't file for bankruptcy, which creditors know will leave little or nothing for them after costs and fees are paid. So obviously, to make an out-of-court workout work, you need to have enough business cash and assets that you can make at least partial payments on your debts. So if you're flat broke, your creditors will have no incentive to negotiate with you. Let's talk now about getting released from personal liability, because that's ultimately the goal here, right? You're running a business and you want to make sure that your personal assets are not attacked in court. If your business is a corporation or LLC, and you haven't signed any personal guarantees or become personally liable for any debts, such as unpaid payroll taxes, you don't actually have to wait around for creditors to sign releases. All you have to do is simply close the business, sell its assets, and pay your creditors on a pro rata basis until the business's cash is exhausted. You will not, don't be worried here, you will not be personally liable for the balance of the debts your corporation or LLC cannot pay. There is a drawback here though. The downside of this approach is that by not getting signed releases, you open yourself up for years of litigation, because you can be hounded for years by collection agencies and possibly even been sued. So if you are sued, if you are brought to court, you'll at least have to file a response in court pointing out that you aren't personally liable for the debt, and you may have to hire a lawyer or appear in court by yourself. Worse, a creditor in that case might even argue that your corporation or LLC was just a sham to help you defraud creditors and that it was really just you running the business. Now, this is in the legal jargon, this is called trying to pierce the veil of the corporation or LLC. If the creditor were to succeed in court, you would be personally liable for paying the business's debts. So getting releases on all your debts can avoid this. Ask him going through Chapter 7, Individual Bankruptcy. We have covered Chapter 7, Chapter 11, and Chapter 13, Bankruptcy in various shows. You might want to double check our shows to learn more about those forms of reorganization or restructuring. On the other end, if you are personally liable for some business debts because you signed some kind of personal guarantees or because you are a sole proprietor or a partner, you will absolutely need to get all of your creditors to settle with you and release you from the debt. So if even if one creditor refuses to release you from a debt you're personally liable for, all your other settlements may be canceled, they may be nil. If the creditor sues you and takes your property, or you end up having to file for bankruptcy anyway. So remember, we're talking here about some serious stuff. Some of it very complicated depending upon the states where you live, because for bankruptcy you have to think about the federal aspect of things, but also at the local level. It's always good to reach out to a business lawyer who can help you structure things, who can help you plan things in advance. It's better to spend a few $100s to understand exactly what's going on than trying to do trials and errors, especially with the law. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of Sweetie Q. We are still having a conversation today around out-of-court business closure, and I'm talking to you about how to close down your business yourself without filing for bankruptcy. That's the key word here, bankruptcy. We're trying to avoid bankruptcy here. So, in the first section, I was explaining to you the workout process and how to get released from personal liability. Now let's talk about the advantages of doing it yourself. Selling business assets and negotiating settlements yourself, rather than turning them over to a bankruptcy court for liquidation, will likely bring you more money for yourself and also for your creditors. And you will not have to pay the cost of bankruptcy. I'm talking about courts and lawyers' fees. So if you feel some kind of ethical duty to your creditors and want to see that they receive as much money as possible, this may be the best way to go. I want you to keep in mind, however, that if you hire an attorney to liquidate your company for you, this savings might diminish, right? Because the lawyer will also charge you extra. So managing the liquidation outside of bankruptcy gives you far more control over which debts are paid. For instance, if you don't file for personal bankruptcy, you can choose to first pay the debts for which you are personally liable, such as trust fund taxes, a line of credit that you personally guaranteed, or contracts or leases with your personal signature. You might even be able to buy the business asset back yourself, something you might want to do if you are planning to start up a new business after the liquidation. For example, you might want to buy back a copyright, a specialized technology, a patent to use in a new business. Now, this is pretty cool. By contrast, though, in a Chapter 7 business bankruptcy, the bankruptcy trustee, who is the person in charge of gathering and selling the assets, and this person is appointed by the court. This person, the trustee, may not let the owners of a corporation or LLC purchase the company's assets, though this is standard procedure for sole proprietors in individual Chapter 7 bankruptcies. Keep in mind that, especially if yours is a business that required little capital to start up, such as a service business, an accountant, or lawyer, or a consultant, you can easily and legally start up a similar business after a Chapter 7 bankruptcy. Finally, if before the liquidation you paid some creditors, let's say some friends, some family members, some very close associates, at the expense of others, these preferred payments will not be taken away when you wind down your business yourself, as they would in bankruptcy. Right? So here, what I'm trying to say is, let's say you made payments on a loan to a relative or a close business associate in the year before filing, or transferred property for little or no payments in the 2 years or 3 years before filing. A bankruptcy court could take back these payments or property to divide them equally among all creditors. Right? So I'm just giving you a few advantages of doing things yourself. If you love the content's clarity or quality of this show so far, please consider subscribing to our channel and turn on the notification bell so you are aware whenever we drop a new show. And we re-release shows every single day, rain or shine. Also, please, in the comment section, tell us your experience. If you have questions, we will try to answer them. And like this content and share. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of Sweetie Kiwi. I hope you are doing fantastic and still enjoying this conversation here. I was talking to you earlier about the advantages of doing it yourself. Let's now talk about the disadvantages of doing it yourself. First, It's just a lot of work. It's a lot of work. It takes time to advertise and sell or auction off assets and to get each of your creditors to agree to a settlement. So you got to have the preparation, you got to have the planning, and you have to execute. You need to have an agenda. You cannot just do this randomly. No. If you want to do it effectively, you got to prepare. As I said, you have to think about get all creditors to agree. You have to sell or auction off the assets. You have to advertise the sale. The second thing is, once you start negotiating, bankruptcy may not be an option. You often cannot go back and file for bankruptcy once you start liquidating an asset and negotiating the settlements yourself. That's because if you have made any preference payments or invalid transfers, those things will come back to bite you if you file for bankruptcy. So it's very important to understand it's one of those things. Once you choose the bankruptcy, once you choose the negotiating path, the negotiation path, you can't go backwards. Let's talk about getting help. Now, as I said earlier, it's a lot of work. So liquidating your own business and settling its debts outside of bankruptcy will take work on your part. And unless you have only a few debts and thoroughly understand the legal effects of each, it's best to do it with the help of an attorney who specializes in debt issues. So having a lawyer, for example, negotiate for you is often a big advantage if, as is likely, some of your creditors are no longer speaking to you. In addition, the lawyer will know how and when to mention the bankruptcy alternative in an effort to convince all of your creditors to accept your settlement as a better choice. If your creditors agree to settle, your lawyer can also help you prepare the necessary releases to be sure that in exchange for your partial payments, your spouse or any co-signers will be fully absolved from future liability. Right? So it's always best to reach out to a local business lawyer to have more information. All right, folks, this is it for today's conversation. I was talking to you today around out-of-court business closure, how to close down your company yourself without filing for bankruptcy. I was explaining to you the workout process, how to get released from personal liability, the advantages and disadvantages of doing it yourself, and when and where to get help. I will see you another time. But until then, remember, stay marvelous.